Welcome to Legal Minds. This is stage 4, misrepresentation, and it involves remedies and damages. So in a problem question, after you've covered stage 1, stage 2 and stage 3, you move on to this stage where you begin to talk about remedies, damages, and apply the relevant law to the facts of the scenario. The most common remedy is rescission. This is the one that claimants seek out the most, and it's based on equitable principles. Now, a misrep will render a contract voidable. This means that the innocent party has the choice as to whether the contract should remain or cease to exist. This remedy is available for all types of misrepresentation, so that includes fraudulent misrepresentation, negligent misstatement, negligent misrepresentation, and innocent misrepresentation. The remedy of rescission endeavours to restore the parties into their pre-contractual position. In other words, it aims to put the parties into the position they were in before the contract had formed, or in a position they would be in had the contract never existed. However, it's not available as a right, i.e. it's not something the claimant is necessarily entitled to. There are situations where either the claimant loses the right to rescind or rescission is just not possible, and takes us on to bars of rescission. So there are several ways that rescission can be barred or restricted, whatever you want to say. That one of them is affirmation. This is where the innocent party confirmed acceptance of the contract, and if the claimant has affirmed the contract, then he or she will essentially not have the right to rescind it. So what do we mean by that? It means they accepted it. They accepted the contract as it is. In other words, they seemed satisfied by the contract, and they can do this through their actions, and we'll move on to the case law on it now. So in Long and Lloyd, the claimant purchased a lorry from the defendant, which was represented as being in first-class condition. However, almost immediately, the lorry broke down, and the claimant accepted the defendant's offer to repair it, but then it broke down again. And the courts held that the claimant did not have the right to rescind the contract on the basis that he should have taken measures the first time the lorry broke down. As soon as that lorry broke down, he should have taken measures. He should have sought out a remedy then. But because he accepted the defendant's offer to repair it, he affirmed the contract. In Payman and Langiani, which is actually spelled wrong on the slide, the claimant was aware that he had been defrauded. The claimant was aware that the defendant he was contracting with had committed fraudulent misrepresentation. However, the claimant was not aware of his legal rights. And then eventually he contacted his solicitor, and it was held that not knowing what your legal rights are, not knowing that you have the right to rescind, should not prevent the party from being able to rescind. So in other words, although he did not know what his legal rights were, although he had no idea that he was able to rescind the contract, the court held that this did not mean he lost the right to do so. So in other words, the claimant will only lose the right to rescind if they knew they had the right to do so, but didn't. They affirmed the contract knowing they had the right to rescind. That will be classed as an affirmation. Furthermore, if there's a time lapse between the misrepresentation being made and the claimant discovering it, the courts may hold that the claimant had affirmed the contract. So in Leaf and International Galleries, the claimant purchased a painting that was represented as having been made by a famous artist. However, 5 years later at an auction, he was told it wasn't made by that artist, it was a fake, it had been forged. The claimant, however, could not rescind the contract. The reason being was because he had it for so long. He had it for 5 years. Even though it was not the actual painting, he had affirmed the contract. Now, this may seem unjust, but This was the result for multiple reasons. One of those reasons being that if you're going to pay so much money for something like a painting, you should get professionals to check it to confirm that it is the authentic painting. This will also apply where the claimant does discover the truth. He discovers that there had been a misrepresentation, but it takes too long to take action. That will be evidence of affirmation, or where he or she has the opportunity to discover the truth but chooses not to. So when Leithen International Galleries had the claimant purchase the painting and then had a specialist say to him, "I'm a specialist, I can tell you whether or not this painting is the authentic one." If the claimant then refused, declined the opportunity, then that would be a bar to rescission. The next bar to rescission would be if it was just impossible to rescind the contract. For example, if goods have been destroyed, consumed, or lost. And the case I put on the slide is Clark and Dixon, where the judge held that you can't have your cake and eat it. Essentially what this means is, if the cake's been eaten, you can't give it back. It's as simple as that. But what about situations where goods haven't been lost or completely destroyed necessarily, or completely ruined? Well, in the case of Erlanger, there was a phosphate mine, and much of the mine had been dug into, much of the phosphate had been extracted from it. So the question was, could the contract be rescinded because the mine was still in somewhat of a good condition, but many of the materials had been taken away from it. So the question was, could rescission be barred because the resources had been used up? Well, the courts held no, it couldn't be barred because profits could still be returned. So this is an example of when the courts might take a more lenient, a more flexible approach to rescission. So if goods have not been completely destroyed, but if they've lost their value, if they've decreased in quality, then maybe instead of being barred from rescinding the contract, the claimant can receive some of the profits from the defendant, the profits they made from that contract. Of course, this wouldn't always be possible if let's say the defendant didn't make any profits. If they didn't make any money at all, then impossibility of rescission may be the case. So what about third-party rights? Will the court allow a contract to be rescinded if it affects the rights of a third party? Well, the courts are actually very adamant to allow for the rescission of a contract when it will interfere with a third party's rights. It may happen, but it will have to be a very exceptional circumstance. In Phillips and Brooks, a rogue went into a jewelry shop and persuaded the jeweler somehow that he was a celebrity and that he should allow him to take the ring without payment, as it was his wife's birthday, and that he would pay him at a later date. And so he gave him an address, but the address he gave the jeweler was a fake address, and he pawned the ring somewhere else. He sold it on, and he was never to be found again. So no action could be taken against him. However, the contract could not be rescinded at all because the ring was now in the possession of another jeweler, and by rescinding the contract, that would have affected the rights of that jeweler. So this is, in a way, in a way, it links to the principle of buyer beware, caveat emptor. People should be very cautious and very vigilant as to who they contract with and the terms they agree to. So that's a part of stage 4 done. In the next video, I'm going to cover the rest of stage 4, which would be damages for a misrepresentation.